All rise. The Superior Court of Monterey County is now in session. The Honorable Thomas Wills presiding. Please be seated.
Good morning, everyone. Mr. Z-Tribe.
Thank you, Your Honor. Matt Klein, Philadelphia Myers, on behalf of CRC. Just a few housekeeping matters. Number one, both the interveners and the petitioners last night submitted the 5-page briefs on the standing issue with respect to the Fracking, so that briefing is complete. Number two, I'll finish my single subject matter presentation. Mr. Wickersham, I'm sorry, and then obviously we'll get the response to the rebuttal. And Mr. Wickersham is going to address the due process arguments, the affirmative arguments. I believe the county interveners will go next. Ms. Wells is going to have to address some of the points that Mr. Haggard is going to make. Part of Mr. Haggard's presentation is going to respond to Mr. Thompson's presentation yesterday. And Mr. Thompson, unfortunately, is up north with a prior obligation teaching. So Ms. Wells will address that if need be. And then we'll finish off with the general plan arguments. And I think, based on the estimates I've heard, we should be done hopefully by the early afternoon, not before then.
All right.
I did get a chance to look into the Jones and CTLA cases. There's a lot of the California Supreme Court voiced a separate test independently of a reasonable germane test. In fact, they personally left that issue of voter deception untouched. So there is basically a question is squarely presented of whether deceptive and misleading statements in the ballot, if they are, if the provisions of the measure are otherwise reasonably germane to a common purpose and provide a basis for overturning a measure that was adopted.
And that's the footnote 12 question here. So footnote 12 leaves open that question whether you could kind of just do a straight up misleading analysis. And I think the way you're reading Jones is that we have to do the reasonably germane test along with it. I would submit that the paragraph that I adverted to yesterday, I think it's page 1161, assumes that the two are reasonably germane and announces its rule, but I'll address the reasonably germane test right now.
I think that was basically dealing with hiding one provision, and so proceeding hiding one provision of the proposed law in the text of another. Trojan horse effect.
CTLA for sure, Your Honor, but I think what happened to Jones actually, if you look at footnote 5, is they weren't hiding it, they were using it as the selling piece. That's the point of footnote 5, which says the way you attracted voter attention in the parking lots and at the voter ballot booth was by emphasizing unduly and unreasonably the legislative pay cap. And so I agree completely with your reading of CTLA. That's a barrier in the middle of it. No one can see it. It's the insurance provision about lobbying. But in Jones, what actually is doing the work, as it were, politically, is the legislative cap. CTLA is the opposite, because in CTLA, you're completely correct that the lobbying provision is buried. But the thing that is selling the initiative in Jones is the legislative cap. And the thing that they're trying to kind of drag through along with it is the reapportionment rules. And so I think that what happens in Jones, if you look at the court's analysis, is it kind of takes two swipes at the question. And in the first swipe that I adverted to yesterday, and maybe we can pull up that slide again, what the court is saying is, for the moment, we'll assume that these two are reasonably germane. Even if they are reasonably germane, it's deceptive because the first one addresses a non-issue, it's a nullity. And if you're addressing a nullity, that can't be reasonably germane to another provision. In the next part of the analysis, the court,
They found that the implication, yeah, the reality, that legislators do not control their own salaries and thus cannot raise their own pay was not reasonably germane to the reimbursement issue.
Correct.
And one could not say that they were reasonably germane to a common purpose by overgeneralizing that they related to legislative self-interest in a broad sense.
correct, Your Honor, because it's a matter of California law. What was being sold as this problem that needed to be addressed wasn't a problem. And so what the court is saying is you can't have two objects of the legislation. If you pull up slide number 8 again, please, Maureen. What the court's saying is you can't have something that's a nullity. What's to fix a problem that doesn't exist? Be reasonably germane to what was a real substantive provision, which was let's alter the voter redistricting rules, because the first one is a non-issue. And the same thing is true here. We have admission after admission after admission from the county and otherwise that fracking is not going on here. And so what you're asking the people to do is to enact a law that really has no effect in Monterey County as part one of the initiative here. Not hidden, this is the centerpiece of the initiative. For the purpose of dragging along these other provisions here, the wastewater impoundment prohibition and the new wells prohibition. And so as part of the reasonably germane analysis that I was going to get to in the second half of my presentation today, I was going to try to show Your Honor that as in Jones, you're basically trying to tie a nullity to substantive provisions. And that nullity is a bogeyman. It's the thing that gets voters afraid, it's the things that get voters excited, and that's what Jones is all about. But I completely agree that CTLA is a different case because what was going on there is there's a bunch of reform in the insurance industry, and buried in the middle of it is this new rule about exceptions for conflicts of interest.
The court does say, as we shall explain, because we conclude that the initiative, this is in Jones, the initiative measure violates the single subject rule, and for this reason may not be submitted to the electors. We need not reach the questions of whether the measure constitutes a constitutional revision rather than an amendment, or whether its allegedly misleading aspects are sufficient in themselves to warrant an order withholding the measure from the ballots. I don't think they really reached that question.
I agree that they didn't reach the straight up fraud question, but what they're doing is in their reasonably germane analysis, and that's what I'm going to do today, and this is what I think they're doing here, is they're saying these two things can't be reasonably germane to one another because one is a nullity, doesn't exist, it's a fake issue, and the other ones are real substantive issues. And so you can't think that the voters were actually addressing one subject when one of the subjects was the bogeyman. And I think if you look at the court's analysis, as it's going through it again and again and again, it comes back to the chief evil that the single subject matter rule is being used to guard against is voter deception and manipulation. And they refer back again and again and again to this deception that this prohibition or this permission for legislators to set their own salaries literally did not exist.
Well, just because there was no fracking effect going on in Monterey County doesn't mean that voters will be powerless to outlaw it, assuming it's not preempted, but just put that aside. They don't have to wait for trouble to happen in order to rule it out.
But the way that they sold the ban, Your Honor, and we can go to slide number 17, please. Finding number 3, this is the way they sell the ban, is fracking can become widespread in Monterey County. And the undisputed evidence is that not only is there no fracking here, but as all the experts testified as the county itself, and these are the AR sites that I was citing to, they said it's just not happening here. It would be counterproductive.
Clearly, the implication is that fracking was in existence, and it implied that it could become widespread.
That's the title, Your Honor, of finding number 3. It's not an implication, it's an express representation of the voting public. Fracking could become widespread in Monterey County.
Well, yeah, but what's the dam limit risky oils operations initiative?
Yeah, so the ban fracking part of it is to me the nullity here. And it's the nullity being tied together with these other substantive provisions that gets to the heart of the deception. And I understand Your Honor's, again, reading of CTLI, but I do think Jones, what it's talking about it again and again and again there, because cases do go broadly and say, look, if you're going to reform the way that we elect and compensate legislators, that's fine. But what Jones says is, but the problem here is you actually attacked this thing that doesn't exist, and you admitted that you did it to get voters fired up about the initiative.
But it exists. It just wasn't taking place. Isn't the real danger here that the provisions of this ordinance outlook, without fully disclosing what the effect would be, certain types of oil operations that the average person on the street simply is not equipped to understand?
That's absolutely.
We've had tons of technical information provided to you that explains what an integral part to the production of oil in South Monterey County, steam injection plays. And while the ordinance, it has been represented as permitting, it neither does so expressly nor in its effect. Isn't that the limitation?
It is, Your Honor, and that was the second source of voter confusion that I was talking about yesterday, and I'll show you where that comes. It's in slide 28, please. This is in the official ballot materials, where it's represented that Measure Z preserves current oil jobs and county tax revenue. And we know that to be an utter falsehood, because what we were told by the interveners in this trial a few days ago is that no new wells means no new wells. Companies like CRC can't drill any wells, which means their land is valueless, and they're not going to have to pay taxes on land that has no value. We've been told, yes, it's going to slow down operations. It might not affect an immediate taking into their submission as to the Chevron and Aera operations, but it's sure going to slow the thing down, and in 5 years it's going to be gone. So all those jobs, all that revenue is going to be gone. And if we can look at the 2 new slides that I prepared this morning, having seen the other side slides, sorry, we call those up, please. These are the new ones that I prepared. Your Honor, I'll just read from it. It's literally quotes from the county council. So the county council argued vociferously. No, those are Heather's slides for her next argument. Maybe Heather, you can go back and show Your Honor where they are. The county council, Your Honor, appeared at a county hearing. This is at AR 217 to 222. And the county council again and again asked that an impact report be prepared so that the voters could be educated on the impacts of Measure Z. He said that the impact reports would provide significant information on what the physical impact is. For example, if the industry has to end their production, what is the tax impact to the county? And the proponents of the initiative threatened to sue the county if they prepared that type of report, and convinced the county in a very close vote to not prepare those reports. So yes, that risk was real and palpable. To go to the next slide. The impartial analysis that the county did prepare, and this is all it could say, This is at AR 373. Again, not evidence we're pulling from some random person. This is in the county's submission of evidence in this case. They said the full impact of the measure is uncertain because it is not known to what extent ban practices are either utilized or necessary. It, quote, appears that the measure allows certain activities, and this is the whole debate about, there's no new wells, no new net wells or something else. Is routine maintenance allowed under the fracking ban? All these other uncertainties. And so
But isn't that true?
it's wildly uncertain, it's wildly unclear, and that is the risk that we're dealing with.
Well, there's a difference between being uncertain and unclear and being, at that point in time, factually, demonstrably, palpably false.
Well, what happened was, Your Honor, as we talked about yesterday, the assessor said, this fellow whose statements they're now running from, the assessor said this is going to shut down production. This is a county official acting in his duty and role for the county, making representations. And again, we didn't go out and get a random declaration from him. This is from the documents that the county provided. He says it's going to shut down oil and gas production. And what are the voters told? They're told nothing about that. That fact is hidden from them. And sure, one of his senior people shut it down and kept it out of the ballot materials. But if impact reports had been done, it would have revealed these facts, and those facts were hidden from the people. So those are the twin evils of Measure Z. One, it attacked a problem that didn't exist. And then two, it affirmatively misrepresented to the public what the impacts would be. And again, these are their own affirmative representations in ballot materials. If you go back to slide 28. And I was going to show you the video yesterday, but their lawyer who kept on showing up at these meetings said it means that no loss of taxes, zero loss of taxes. So we do think, Your Honor, that we're fairly within Jones. I don't think CTLA, I think what CTLA teaches in this case, and this is what we mostly cited it for, is the observation of CTLA that, hey, just retreating to the notion that, hey, we're regulating the insurance industry saves this initiative from a single subject matter challenge. And it also, by saying, hey, we're just regulating the oil and gas industry, it doesn't save this measure. That's the main import of CTLA in this case. But the main import of Jones is when you're taking this thing that is effectively a nullity, banning a practice that everybody admits doesn't exist, is highly politically charged, is the absolute centerpiece of their campaign. They're just drubbing people with it, banging them over the head with it. And you tie that nullity to two highly complex, highly impactful other parts of the oil and gas industry that really aren't related. That's where voter deception arises. And you saw the Monterey Herald, their editorial board, say this explicitly. And what Jones says is, take a common sense approach. Think about what a reasonable voter would do in this situation. So if you go to slide 5, please, Maureen. Here's the test. Safeguard against confusion and manipulation. Protect the integrity of the process. Go to slide 6, please. Again, realistic and common sense perspective. Average voter. And let's just look quickly now at the kind of reasonably germane test, Your Honor, which I was going to try to address yesterday. It was half of the presentation, but I want to address now. If you go to slide 35, please, in your book, and Maureen, if you can pull it up on the screen. Here's how the purpose of the measure, Your Honor, is articulated in Measure Z. And it's this long sentence. Purpose of this Protect Our Water, Ban Fracking, and Limit Risky Oil Operations initiative is to protect Monterey County's water, agricultural lands, air quality, scenic vistas, and quality of life by prohibiting the use of any land within the county's unincorporated area for well stimulation treatments, including, for example, hydraulic fracturing treatments, also known as fracking, and acid well stimulation treatments. And the next two sentences, it says the initiative also prohibits disposal using injection wells. In the final sentence, it says the initiative also prohibits drilling new oil and gas wells in the county's unincorporated area. So I just want to walk through a few problems with the way this initiative is drafted and why they don't escape the single subject challenge here. Go to the next slide, please. What the cases have taught us, and they start with Brosnahan, go through Jones, CCLA Chemical Specialties, is that these broad purposes, eliminating nutrition advertising, ensuring public disclosure, regulating the business of insurance, making sure that there's voter approval, dealing with political issues, dealing with public welfare of the government. None of those is specific enough. And yet, go to the next slide. Every time we see one of their presentations begin, they start with this very efficacious language to protect Monterey County's water, agricultural lands, air quality, scenic vistas, and quality of life. And what the case law instructs us to do is to actually take those words seriously and think about them and say, could a voter understand what the focus of this thing was, or is it too broad, too capacious, too open-ended, subject to too many different meanings, such that it is really addressing different objects. And let's look at the definition of the word quality of life. We can skip ahead 2 slides. What does Black's Law Dictionary tell us? Says that quality of life means the daily activities that people undertake that have been enhanced by external factors, which is pretty broad and open-ended. I will tell you that the quality of my life, Your Honor, the last couple of weeks has been terrible because the Dodgers lost the World Series. Okay, but I also have enjoyed the great outdoors. I've enjoyed spending time with my kids. These factors are natural factors such as good water, clean air, outdoor activity, and open spaces. So that fairly embraces some of what Measure Z talks about. But right in Black's Law Dictionary, it tells us it also relates to how well a person with a disability is able to live as near as a normal life as possible. And so quality of life is one of these kind of open-ended things that it's a lovely thing to strive for, but it doesn't bring the initiative into the narrow focus and scope of the single subject cases. If you take a look at a lot of the Brosnahan type cases, these are the major criminal reform cases, they'll say, this is a major criminal reform statute. If you look at Prop 66, the Briggs case that got decided this year, it was the, let's really reform the way we deal with death penalty appeals. This was not sold as a big reform of the oil and gas industry. This was not sold as the shutdown of the oil and gas industry that we're now, after the initiative, hearing about. Your Honor, you can't allow the stay to happen, they argue, because that won't let Measure Z have its effect. Your Honor, no new wells means no new wells, and we want people like CRC to be shut down. If they wanted to enact some big reform measure that really constricted the oil and gas industry and shut it down after 5 or 10 years, they should have told the people that, and they didn't. They couched it in terms of these very broad, open-ended concepts like quality of life, focused on the fracking ban, and then made affirmative misrepresentations about how it wouldn't impact jobs and it wouldn't impact taxes. So if you go to the next slide, please. And Mr. Orradre, sorry, one after that. So Mr. Orradre showed this slide as he was talking about the severability question, and he argued, with Your Honor, the voters were presented with these 3 questions. They're severable. Even if you knock out, 2 or 3 or any one of them, all of them kind of stands on their own. And that was the severability argument that they were making. And they said, well, clearly voters knew what they were enacting when they did this. Well, let's see what the Monterey Herald had to say about that representation. It's the next slide.
Yeah. I don't really think that this was, it's very interesting, but it's not really admissible to the extent that it may show the payer overlaid error what the undisclosed effects of this measure may be.
Or Your Honor, a fair, persuasive, and again, not controlling, not binding reading. When I say that it's reasonable to make this inference, when I say that it's a common sense point of view to make this inference, when I say that a lay voter is going to make this inference, I think that this is at least persuasive that that's not an untenable claim that I'm making. when the editorial board says, hey, when asked to detail specific water concerns, the proponents' answers were incomplete and not inaccurate. The fuzzy language of their initiative should be the real red flag for voters. All I'm saying, Your Honor, is our reading of the materials, our reading of the ballot materials, our reading of the pro and con statements that were out there, when we say that they were misleading, they were hard to follow, that there was a likelihood of voter deception or manipulation, all we're doing when we cite this is to say that that's anchored in some reality.
But I posed the question earlier, and I'll repeat it. Isn't there a certain amount of puffery and duplicity in any political campaign, or many of them, I should say, not all?
You know, I thought about that question a lot last night, Your Honor, and here's where I come out on it. I do think in individual elections for individual politicians, we have come to the point in America where you can pretty much say anything. And people expect you to say anything, and there really are no roles for the courts to police what they're saying other than saying a defamation action. But the California Constitution, by act of the voters themselves, has said we need a limit in politics. When we're asking the voters to engage in acts of direct democracy, we do need a limit on what type of information can be presented, what types of materials are misleading or not, and that's a single subject rule, and that's cases like Jim's. And so yes, there's a lot of back and forth in these initiatives. There's a lot of pro and con arguments, as was referred to the last couple of days. There's this new practice of putting up competing initiatives. We had a crazy one in Los Angeles where it's hard to figure out whether you're voting to ban plastic bags or not ban plastic bags. But the courts do play an end bedrock rule, and it's part of our separation of powers in California engrafted in the Constitution. And so, one of the arguments has been, look, maybe we can sever out the fracking ban of Measure Z, because that's what people really wanted. I think that would be one of the most pernicious results, Your Honor, because that was the bait and switch. And so I don't think that's not what Jones says. Jones, I think, was confident that one of the reasons why the act in Jones was passed was because it did cap legislative salaries. And the court in Jones didn't say, well, it's pretty clear that's what people wanted, so we'll let it stand. Here, I do not think we should let it stand.
Well, if indeed it's what the people tell, why shouldn't it be allowed to stand?
Because the single subject rule itself, cases like Jones, stand for the proposition that you cannot lay that bait and have the force of law in California. And one way to think about that, Your Honor, is to go back actually, we can go to slide 48, please. So, Your Honor, if you look up on the screen, this is the actual initiative that passed the single subject rule back in 1948. And these were the findings in enacting the single subject rule. And Justice Moreno talks about this in his concurring opinion in the Dooley case. But the busy voter does not have the time to devote to the study of long worded propositions. Here, I think it was a 27-page proposition. And must rely upon such sketchy information as may be received through the press, radio, or picked up in general conversation. If improper emphasis is placed upon one feature and the remaining features ignored, or if there is a failure to study the entire proposed amendment, the voter may be misled as to the overall effect. So that's the first purpose of the single subject rule that the voters enacted in 1948. And Your Honor, if we could go quickly to slide 47. For a significant period of time in California, from 1948 through the 70s, through much of the 80s, people did view the single subject matter rule as kind of a dead letter. But there was a really important law in the Article 91. They called it out as being increasingly out of control. You have the CTLA case in 1988, Chemical Specialties case in 1991, and then Jones, which embraces and adopts the reasoning of both those cases in 1999, and says, no, it's not a dead letter. And if you look at Justice Kennard's dissent in Jones, she's the only one who dissents there. She dissented on procedural grounds having nothing to do with the merits of the argument. She even acknowledges that the courts in California can and should be criticized for not giving life to this initiative. And to be fair and candid, there have been many cases upholding statutes before Jones and after Jones, the single subject rule challenges. But in none of those cases where they're upholding the statute, do you see the same twin deceptions that you see here. And just to turn quickly, Your Honor, to the two cited cases that PMC relies on most heavily, go to slide 45. Talked a lot about San Mateo in different contexts. This is the case, Your Honor, that has to do with whether there's a 6B provision or a 6C provision that you heard a lot about. But San Mateo, from a single subject matter rule perspective, is pretty easy. San Mateo County enacted this coastal land use plan in 1980, and it required certain easements if you wanted to engage in development. And the people got worried that the county was getting a little bit weak, and it wasn't going to keep that plan in place, the land use plan in place. And so they were asked to reaffirm the plan 6 years later and to limit the county's power to change its elements. And it included the same provisions as before, requiring easements and limiting certain types of development, including oil refineries and offshore wells. But there's no evidence or discussion in Judge Klein's opinion in that case about whether the measure was considered or not. Zero. And there was no bogeyman provision used to drive the vote. No bait and switch about impacts. And all provisions related to it, including the reaffirmed in 1981. And so they cite the case saying, hey, look, that had to do with oil and gas, and there are these kind of different provisions dealing with different types of development. But the subject of that case was all just reaffirming this plan that had existed in place in 1980 and just saying, hey, we the people are the only ones who are going to change the plan, and you, the county, cannot erect it. It wasn't drastically rechanging and reshaping the way that San Ardo Field is going to work here in Monterey County. The next case, Shea Homes, which is the next slide, 46, very similar, Your Honor. There were pockets of Alameda County that had always been used for agricultural purposes and open space. And the measure said, we're going to keep that. There were a lot of urban use permits being pulled or applied for. And the proponents of the initiative said, no, you can't, we don't want you to be allowed to rezone for this agricultural land, which has always been agricultural land for urban use. And we do not want to expand the number of landfills because all that does is allow further urban development. Again, there's no evidence in that case, no claim in that case that anything was done in a misleading fashion. There was no bogeyman provision used to drive the vote. And there were no doubts about the impact. All they were doing was maintaining the existing agricultural land uses. And unlike here, they weren't trying to ban or impair existing decades-long uses. And so, Mr. Haggard is going to cite a lot of cases to you upholding single subject rule challenges, and there are many, Your Honor. There are many of them, but I'll represent to you that they do not involve the twin deceptions at issue here or acts of voter manipulation. And so I think we are where I began. If you go to slide 49. Is that the initiative needs to be struck down altogether. There's no rule of severance when it comes to single subject challenges. And with that, Your Honor, I will sit down and hear what the county interviewers have to say.
Thank you, Mr.
When you're on the on behalf of the County of Monterey in all cases,
Morning.
I was hoping, based upon your initial comments, that I could shorten this significantly, because your initial comments, I think, accurately characterize the actual test that's applied in these cases. There were some comments and questions that I think required me to go through the presentation, but where the court began is where we need to end up. There is a very specific single subject test. It's one test. There isn't a Jones test. there isn't an adequately sufficient test or whatever the slides have said that I'll refer to. There's one test, and this measure absolutely, unequivocally passes that test. So what I would like to do is work back through the actual legal framework for the single subject rule, restate the well-settled test that courts apply and have consistently applied, review some of the key cases. I have a chart that will show those cases, and all of those cases apply the same test and are designed to address the concerns that plaintiff's counsel has articulated, among others. But the test is the way you address those concerns. You don't create a new test. And I'll also point out several cases where the exact same type of argument of extending the law or changing tests have been made. And those have uniformly been rejected. And then along the way, what I'm hoping to do is get to the court's question that the court has raised several times in part of the evidentiary question. What should courts look at in doing a single subject analysis and even more broadly when looking at an issue? That's my plan. So we go to the next slide. Let's start with the framework and look specifically at what the Constitution says, because I think it's very instructive here, given the nature of the challenge and the timing of the challenge that is now being asserted. If you look at Article 2, Section 8D, what you can see from that is that it contemplates both a post-election challenge, like we have here, but also it is permissible and expressly contemplates a pre-election challenge. And the Jones case and other cases relate to that kind of a challenge. And I'll get to more detail about footnote 12, but there are ways in which these issues could have, and I would assert should have, if they rise to the level of concern that plaintiffs are now articulating, they should have been brought pre-election. In the Jones case,
Are you suggesting that by not
I'm not suggesting
raising these challenges,
no.
they've somehow waived the ability to challenge the post-election?
No, I'm not, Your Honor. But I am pointing out that an inherent part of Article 2, Section 8D allows for such challenges. And I will also point out that the Jones case talks about the value of bringing this type of a challenge that you're now hearing, which is essentially re-arguing of the campaign based upon an allegation that either the way the campaign was run or the language in some of the material was false and misleading. There's a suggestion that that type of challenge should be brought pre-election. And that waiting and not doing it does create cynicism about the initiative process. And that's Jones at 1154. There's also a specific election code process. That's 9190 of the election code that deals with challenges to ballot arguments, impartial analysis, and that's specific to things that are false and misleading. And everything that I hear from plaintiff's counsel really relates to those questions. And so to be asserting them now in the guise of a single subject rule challenge is not consistent with what the single subject rule is really about. Let's go, I'm sorry, let's stay on this slide for a second. It's absolutely true that the single subject rule is a constitutional safeguard. And as Jones says, it was adopted to protect against multifaceted measures of undue scope. The courts have articulated and identified several purposes related to this single subject rule. One is the one stated there. One is the one that's really the focus of the main argument from plaintiffs, minimizing the risk, not actual voter confusion and deception, but to minimize the risk of voter confusion and deception. And then there are very clear statements that this rule, single subject rule, and I'm referring specifically to the Aera case, plaintiffs have cited and I'll come back to. This rule is not intended as a means to overthrow legitimate legislation. And really, if you think about what plaintiffs are doing, they're trying to extend or repackage the law by taking one of the purposes of the single subject rule and making that in itself the test, rather than looking at the actual test that's designed to achieve that purpose among others. Now, even though the single subject rule is an important constitutional safeguard, all of the cases uniformly acknowledge that it must be liberally construed because it's important and vital to uphold the people's right to the initiative process. The Brosnahan case says that. The FPPC case that I'll refer to also says that. FPPC case is instructive too because it deals with a very complicated, comprehensive situation about essentially the entire Political Reform Act with all of its complexities. And FPPC says, absolutely, the voters are allowed to and should be allowed to deal with that kind of a comprehensive, complex issue through the initiative process. And the single subject rule shouldn't be a ban to that. I believe I heard a reference to sort of narrow scope or limited scope of how you look at the initiative under the single subject rule. That's not its exact opposite. You need to look, the courts have repeatedly held that you have to look broadly at it, at the initiative, and uphold the right of the people to act by the initiative process. Another point that I think is crucial given the court's question about the complexity of the measure here is that courts presume that voters acted intelligently. And courts have been charged with not second-guessing the wisdom of the decision.
Courts ordinarily.
True, that's right, absolutely. I think, though, that that's a presumption that all the cases have followed. And I'll get to why that presumption really needs to be in place, because of the complexity of trying to reassess what individual voters might have understood or not understood. And that brings me to this idea that there's some average voter test that the plaintiffs have suggested the court needs to follow. There is, in the CPLA case, there's what I would characterize as a passing reference to average voters and what the court refers to as sophisticated, well-informed voters. But that's not the test. The test is you presume that the voters knew what they were doing. All voters are presumed to have that. And then you look, as I'll talk about, you look at the measure itself, you apply the test, and you reach your conclusion.
Can the court presume that the voters of Monterey County knew the indications of how oil operations in South Monterey County prohibitions would be on the ability of those to continue?
You can actually look at the material that was put forward in the argument against the measure, along with other sources that were actually before the voters. And you can determine from those that these issues, with all their complexity and all the different arguments that the court has heard all week, were presented, and obviously not in the level of detail we've heard here, but the argument that Measure Z would cause the immediate ending of oil and gas and impact the economy and require the loss of oil and gas jobs, all of that was argued. And the voters had that in front of them, and they reached the conclusion that they reached. And that's really what the court, if it looks at all at anything beyond the measure itself, that's what the court has to look at. Another key component, which also is very relevant here to this idea of what really is log rolling, the concept of log rolling, that you put in the one and everything follows along with it. The Amador case speaks specifically to that and says that there's no requirement to show that the individual provisions themselves were capable of gaining separate support. So those are the actual presumptions and framework that the court should bring to the application of the test, which, if we go to the next slide, is very straightforward, has been repeatedly upheld, even when it's been urged that courts should extend or change it. So the test is this. Initiative complies with the single subject rule if the provisions are functionally related to one another, or the provisions are reasonably germane to one another, or to the objects of the enactment. That's the Harbor case that's cited here. It's stated also in the chemical specialties case that finance have referred to. And this is the test. There's no other test. The courts have also said, and Brosnahan reaches this point, that you pass this test if you pass either of these options. Generally, the courts have focused on the term reasonably germane, but as stated in Harbor and chemical specialties, it's really an either or. If it's functionally related to one another, the provisions themselves, or they're reasonably germane to themselves or to the objects of the enactment.
But there's actually language in California's for an open primary versus an McPherson case in 2006 that said that in applying the reasonable germane test, however, our decisions, California Supreme Court, uniformly have considered only whether each of the parts of the measure is reasonably germane to the common aim, purpose, or subject, and have not separately or additionally required they also be reasonably germane.
Right. It's an either or. It's not. You don't have to show all of those things.
So the language of the case almost suggests you don't even the reasonably germane or another test is almost never.
True. I think most of the cases, the Harbor and chemical specialties do. Harbor, I know, talks about it being either or and talks about the functionally related. And cases do talk about that, but you're right. I mean, the reasonably germane component is the term of art that courts have used. Cases, I'm going to talk about four cases that where there's been attempts to do what plaintiffs are attempting to do here, which is expand the test, change it. In Amador, at page 232, there's a discussion of, the Amador is a Prop 13 case, Proposition 13. And this is where there's an argument that the test should actually be not just reasonably germane, but you should actually have to demonstrate that each of the parts of the measure were capable of independent approval. And the court said there's obvious difficulties in proving that. How would we go about doing that? That's also a far too strict test and lacks support in the case law. The Brosnan case, also in that case, the plaintiffs were arguing about that that should really be that parts of the measure should interlock. And the court said that's not the test. We don't require absolute interlocking of the different provisions. In the FPPC case, there was a contention without really kind of offering a substitute test, but there was a contention that a more restrictive test should be used, and the court rejected that. So let's get to the argument that the Jones case somehow creates something new, and the court, Your Honor, in the opening statement discussion, really identified why the contention that footnote 12 creates a new test in some way is not what happened in the case. And again, this is a pre-election challenge case. And as the court noted, footnote 12 basically says that there's a contention, the petitioners contend that as a separate basis of keeping this measure off the ballot, the misleading nature of the measure for the reasons that the court talked about and was discussed with plaintiff's counsel earlier about the power of the legislators to affect their own pay. But the contention by the petitioners is that that should be an independent basis for keeping the measure off the ballot. And that's a contention that's outside the single subject rule. And the court says that. We've already decided on the single subject rule. So we're not going to answer the question of whether there's an independent, non-single subject rule analysis that we might be able to engage in to keep something off the ballot.
I agree. They left that issue.
Well, not only did they leave it open, they left it open outside of the single subject rule.
Correct. Correct. So, at some point, I want to ask you, is the court powerless to do anything if there are flat-out misrepresentations in ballot materials about this measure?
In ballot materials, there's a process that I mentioned, Your Honor.
Right, that's the elections code process.
Yes.
Post-election. Is that our court powerless? And I've not seen the case, nobody's pointed one out yet, that even says that the court can strike a measure down because there were outright misrepresentations in the ballot materials about what it's about.
I think you're exactly right. That's why if you are affected by a measure, you need to engage in the process. And there's a legal process to deal with that pre-election. You believe that statements in the argument for the measure are false and misleading. You need to come in and prove that. And then the court at that point in time is absolutely able to strike things, and does. It happens. But after the fact, I'm not aware of a case that says you can second guess what the voters said, you can reassess what the initiative says and say, well, this isn't actually true, therefore the whole thing's falls apart. I'm not aware of a case that says that. So let me just pause here. If the court doesn't need to hear this, we don't have to go into it, but I do want to respond to a question about what can the court look at? I don't have a slide for this, but I think it's important. I agree with, I think on Tuesday, counsel for the interveners talked about the Burger King case and what the court should look at, and the ballot, the text itself and the ballot materials. In the single subject rule context, there are times when the court judicially notes the widespread discussion of a measure, and at least my reading of those references really are used to show that there's less likelihood of voter confusion and risk because it was well thought and well debated, and so everyone had the opportunity to do that. So I think we need to recognize that there is that line of thought.
It's been considered, it appears no cases really involve litigating the issue of whether those materials should be considered. The court is practical matters done so at the higher courts. And that's what I raised the question. And the result of the table is to jump out of the gears this morning, as was mentioned in the Monterey Herald. The Monterey Herald article, as I said, did lay bare the issues with respect to measures not being reported. And it was pre-election. So, I think the court can. It's sort of a gray area because, again, it's never been thoroughly looked out, but the court can consider it. It may have been discovered late in the game, but nonetheless, it was a part of the election.
I would characterize this as the law as being the court is free to judicially note general discussions of issues. Our position is that to actually really assess an individual newspaper article or use that as part of the decision-making process, we think would be inconsistent with the cases. We don't think that the Jones case, which really, if you look at the footnote referenced in the allegations, it's a summary of what the petition actually said. And it's not materially used in the Jones case for anything. It's certainly not key evidence that the court relied on. I've already talked, Rob Mann just talked about the general notice of the fact that there was this broad discussion of issues, and you can't argue that the political cartoon is in the dissent, it's in there. But again, it's not, to my mind, I'm not aware of a case that hinges this decision on that kind of material. And our position is really, the test itself focuses on the text of the measure and nothing beyond that. One of they reference chemical specialties where they talk about a review of the history of the measure as if that was some kind of assessment of detailed discussion back and forth that's outside the text and the ballot initiative. That case, what they used that for is they noticed that the 5 measures that were then rolled into one initiative had independently been rejected by the legislature. And they say even there that even if log rolling alone, that does not invalidate. They just essentially use it as for the support for their application of the independent single subject rule test. And one other point, there was a discussion yesterday that somehow other bodies of law, I think the reference was to discrimination cases, that somehow you can pierce the mind of the voter, you can pierce the mind of the legislature in certain situations. That those just don't have any application here. I'm not aware of any case that says that they do. If we go to the next slide. I'm not going to burden the court. You have the presentation. This is summary of basically the cases that have been cited where single subject rule challenges have been upheld. They do involve questions about voter understanding the issues. Amador certainly does, FPPC does, and allegations that there have been deception. I can't say that every case on this chart that was a material issue, but clearly the whole point of this exercise is to protect one of those purposes. So there's discussion in these cases. But for me, the point of these cases here, I mean, if you look at FPPC, for example, is a very broad, different requirements, very complicated. And the court had no problem finding that they were reasonably germane. Antelope Valley Proposition 13, which people are still fighting about what it means. That was held to be reasonably germane. If we go to the next slide. Other cases where very broad categories, even dealing with different issues, not focused on just something like oil and gas land use, but the different issues from the juvenile justice system to criminal gang activity, for example, in Manduli. Those have been upheld. Go to the next slide. Maybe the next slide as well. I believe, Your Honor, that all of those just were all post-election challenges. These are the three cases that have been cited where there was an invalidation of either the measure being on the ballot or the measure itself. In one case, on the single subject rule. And again, if you look at the actual subjects and the broad range, for example, in chemical specialties in particular, maybe dealing with warnings about household toxic products, insurance provisions regarding supplemental Medicare and advertisements related to that. And then you jump down to the fifth point about requiring disclosures of investments related to South Africa, at the time of apartheid. It's very disparate. And so the first and the third are pre-election, and the middle one is post-election. You can see that the types of subjects are very, very, very different, and that's what the court found. Let's go to the next slide. So, under this actual test, and given the liberality and construction of the test, whatever the court finds in all the arguments that have been presented about other issues regarding the measure passes this test. It should pass very easily. It all focuses on oil and gas land uses, the three different components, all address the different components of that land use and the impacts associated with that. They functionally relate to each other. They relate to a broader topic, which tends to criticize that the purposes are about water, tidal pressure, air, scenic vistas, quality of life. But those things are all impacts related to the oil and gas land use. Again, whether you believe it or not is not the question. They all interrelate and are reasonably germane to that topic. This is not just a general packaging up of a bunch of different things, related to public disclosures or campaign reform or campaign disclosures, and just generally saying, well, they associate with oil and gas operations. That's not what the measure does. And it's not like the CTLA situation where there was just a general reference to, well, all these things generally relate to insurance industry. That's not the case. The allegations that you've heard all week are that this is major impacts to oil and gas operations. And so this isn't a general reference reference oil and gas. There was also a reference to the fact that the measure is somehow, well, problematic because of the statements about protecting the oil and gas industry and impacts to the industry itself and the economy were not fully disclosed, but in finding 13 of the actual measure, it talks about that there's a desire to have a sustainable economy, and so there's a specific reference in the measure itself that addresses that concern. So, go to the next slide. To the extent that court has concerned about whether the voters had the information to at least assess what the impacts might be and hear the different arguments. Here are the record sites, so the administrative record. Intervenors Council is going to go through these in detail as an integral part of their presentation, so I won't go through them in detail myself, other than to say, has been said before, that the voters in all the official material were presented with the three components of the measure at each stage of the discussion. But I will, I think if we could switch to the Elmo, there are a couple additional record sites that I want to just call up to address some of the contentions about the voters maybe not having all the information. This is the actual, this is AR 362, the fiscal impact statement, the official one prepared by the county auditor for Measure Z. And it discloses that this would have significant impacts on the oil industry, that it would decrease, could result in a decrease in oil extraction and have a negative impact on financial activity, including impacts to jobs and wages in the oil services industry and related consumer spending, resulting in a decrease in sales and other taxes related to the industry. And I'm not going to belabor the point about this, what the plaintiffs have submitted was, I think, request for judicial notice, Exhibit 2, I believe that that's right, cite the supervising assessor statement, but this is the statement from the county about the effects, and it discloses that it could have very, very significant financial effects, both to the industry and to the county. Let's go to AR 367. And Your Honor, this slide is sort of back to my point I was trying to make earlier, that the voters had the information about the impacts in the form of the arguments against the measure. And it's remarkably similar to what we've heard here today. You can't afford it, it's deceptive, it's deeply flawed, it'll shut down oil and gas production, it will lead to the shutdown of oil and gas production, it'll put thousands of workers, or nearly 1,000 workers out of their jobs, it'll put the county at risk, the county would be devastated by Measure Z. And then the last slide, AR 375. Again, this is a rebuttal argument the voters had when they considered the measure. And again, it makes all the arguments that you've heard, that it will lead to the shutdown. It's deceptive because fracking does not occur. So they saw that. Millions less in taxes for schools and public safety. The importance of the oil industry to Monterey County and how much property taxes that are generated. fact that it would result in litigation and potential legal liability, and again, that the measure is deceptive, costly, and deeply flawed. So the voters had all that information when the voters made their decision. There was a slide in the presentation that plaintiff's counsel didn't get to, talking about maybe this could be further fleshed out through discovery. Clearly that, in our view, is not something that can be appropriate. And if we put up the last slide, AR 416. This is just the official tally of voters voting on the measure. The number 73,877 voted for it and 57,832 voted against it, for a total of 131,760 voters. So the idea that you'd have to go and figure out what all those voters had in their minds to determine whether they actually understood the measure or were deceived by the campaign clearly shows that that is, as the Ember case said, it's an unworkable standard. It can't be done. So let me just check one other thing on that. Your Honor asked a question about whether they can be puffery or arguably deception in campaigns, and I would say there's a political process, and there are ways to check that process if people believe that people have crossed the line, and Election Code 9190 is one of those where you can actually do something about it. But to reassess and re-guess what the process was now, after the measure's been adopted, I think is not appropriate. I think, Your Honor, one other thing, sorry. The reference to the county council's discussion at AR 217 to 222. The reality is that that fiscal statement that was presented has all the information about the impacts. And if you look, if Your Honor just were to look back at those 3 slides I put up, the fiscal statement and the arguments against and the rebuttal, those are basically encapsulate all the arguments that we heard today. So, Your Honor, with that, unless you have any questions.
Thank you.
Good afternoon, Your Honor. Peter Browder for your meeting. Morning. Pardon me.
It's been long.
It's early. I'd like to, could you put a slide? While we're waiting on that, I'd just like to reiterate the initial point that counsel for the county made so clearly and well, I think, which is that most of what we've heard from plaintiffs is a request that the court depart from the clearly articulated standard and consistently applied standard for single subject challenges, which asks whether or not an initiative's provisions are reasonably related to a common subject, theme, or purpose. And I think it's clear on the face of Measure Z's 3 policies, land use policies, that all of them relate to the purpose of, to the theme, to the subject of controlling and dealing with the environmental and land use implications of oil and gas production. And I think that, again, counsel for the county put it well when he said that essentially what plaintiffs are asking the court to do here is back into a finding of a violation of the single subject rule by virtue of one of the policy goals of the single subject rule, which is to avoid voter confusion. And I think, Your Honor, you've obviously read Jones carefully, and I think that your reading of the case was accurate. And the court there specifically relied on its determination that the the provisions in that initiative were not reasonably germane to one another. And the court struggled to find a way in which one could determine that the various provisions in that initiative were in fact closely related, and found that any subject that could encompass all of those provisions would be simply too broad. The political process, or voter participation in the political process, these terms were too broad to satisfy a single subject for purposes of this rule. And as we've seen in the discussion of footnote 12, the court specifically did not use a finding that the voters were misled as a justification for its determination that the single subject rule was violated here. And I'd like to point out as well that Jones is the last case in which a court has found, in a published opinion, that an initiative violated the single subject rule. And there's been only one case in the history of this constitutional rule, and that's the chemical specialties manufacturer case, in which a court has overturned a duly adopted voter initiative on the basis of violating the single subject rule. And again, that's the case in which the provisions reached issues like disclosure of conditions in nursing homes and disclosure of participation in investment in activities in South Africa that might implicate apartheid. These are very, very disparate purposes that were captured together in one initiative. And the Supreme Court, and no other court, has found a violation of the single subject rule since the Jones case. And the Supreme Court addressed this issue of misleading the voters expressly 2.5 years after it decided Jones. Because arguably Jones opened up the idea that courts might use the single subject rule test as an opportunity to conduct a foray into the minds of voters to determine whether or not they had been misled. And this argument went up to the Supreme Court in the Manduli case. That's 27 Cal 4th, 537. And that case involved a complicated initiative that involved changes to the three strikes law, which itself had already been adopted by initiative. And petitioners made these same arguments, evidently emboldened by the language that plaintiffs here have latched onto from Jones, arguing that the initiative violates the single subject rule, quote, because voters were not adequately informed of the changes to the three strikes law affected by Proposition 21, or of the circumstances that these changes concerned laws enacted through prior initiative measures. That's at 579. And the Manduli court rejected this argument. And in doing so, it walked carefully through the official ballot materials, including the ballot summary prepared in that case by the state AG, and the impartial analysis, also prepared by the Attorney General's office. And I wonder if we could actually skip to the last slide, please. A second, one more before that, please. And the court said, petitioner's claim of voter confusion is refuted by the materials in the ballot pamphlet presented to the voters. We must assume the voters duly considered and comprehended these materials. So this is the Supreme Court speaking, I think, to the public, but also to the judiciary generally, after Jones was decided, and saying, in case there was any confusion, Jones did not announce a new text. Jones did not give courts license to peer into the minds of voters based on materials outside of the official ballot pamphlet presented to the voters. And that's why, Your Honor, no case since Jones has held an initiative to be invalid under the single subject rule. Counsel discussed the court's reference in its background statement to the newspaper article attached to the petition. In the Jones case, and the court's allusion to the existence of a robust public debate about the measure in the Brosnahan case and the political cartoon attached to the dissent. I'm not going to throttle that. I think I know that you've read those cases and come to your own conclusions about ballot materials and whether or not they can be admitted. I'd like to just flesh out a little bit the implications, though. I don't think we've talked about that fully, of announcing a new rule, what would be a new rule, that courts can, in fact, examine and consider ballot materials, I'm sorry, I said ballot materials, I meant campaign materials. And the first question here is just the one of administrability. We've seen a variety of campaign materials and campaign statements often pulled out of context by, in some cases in the briefing, people completely unassociated with the opponents of the initiative, statements by a newspaper editorial board. And so it presents an obvious line drawing question from the court. At what point could a court possibly determine what statements to consider, what statements not to consider? And I think you touched on that when you were asking me about this very question during the severability discussion 2 days ago. And you said, where's the line? And I propose to you that the line is that the official ballot materials can be considered and nothing else. And the reason is that the official ballot materials are carefully curated pursuant to an extensive procedure set forth in the Elections Code by which those materials are subject to challenge, and also in the case of the impartial materials developed by the county counsel's office in this case, put forth pursuant to public hearings. And again, if voters or opponents of an initiative or proponents of an initiative want to challenge those materials, they can do so pursuant to the Elections Code. I think the elephant in the room here, and what hasn't been discussed, is the fact that we're seeing a very one-sided description and presentation of the campaign materials. But this was a vigorous campaign, and it was hard-fought. And the opponents, the industry, Chevron and Aera, spent over $5.5 million on campaign materials. And none of those are before the court right now. We don't think that they're relevant. But this narrative that voters were subjected only to materials submitted by proponents of this initiative and were in the dark about any other information just isn't rooted in reality. There were extensive television and radio ads and other materials. And opposing counsel didn't actually show this slide, but the plaintiffs are alluding to the fact that they might like to seek discovery about this evidence that they've alleged is out there about campaign materials and misleading statements. And I'd just like to explain that, what that really does is create a chilling effect for proponents of initiatives going forward, who might be concerned that if they make statements in public on their position of an initiative, they might be subjected to discovery or deposition in the future by powerful opponents of an initiative. And that creates a strong chilling effect on political speech and really works counter to the purposes of the initiative process in California.
The court has no intention of possibly ordering anything of this.
Thank you, Your Honor. I'd like to also address this question of the so-called misleading materials. As Your Honor, you noted at the beginning, campaigns are heated. There's a lot of debate, there's a lot of back and forth, a lot of decisions are made on the ground and very, very quickly. And the ballot question that I put up on the first day of my presentation on severability was pretty extensive. It doesn't fit on a long time. And so proponents and opponents alike need to make decisions about how to frame their arguments and what they want to bring to the voters and how to talk to voters about it and what they'd like to emphasize. And for a court to use the single subject rule to back into a refereeing of those decisions would be unprecedented. And finally, I'd like to address the question of, I think opposing counsel called the fracking ban the first of Measure Z's 3 land use provisions, the prohibition of well stimulation treatments, a nullity. And it's not a stalking horse. Voters were and are very concerned about the impacts of fracking in Monterey County. And it is also the case that fracking has occurred in Monterey County. Voters were aware of that and specifically alluded to that. And
it's in the record, I think, is that some company tried it twice and then abandoned the idea. I didn't see any other evidence in the record that it was actually taking place. Not that that's dispositive of anything.
Sure. So the staff report, the 2008 staff report, the April 2015 staff report, and that's at plaintiff's RJN Exhibit 6, says Vinoco Incorporated did use well stimulation treatments such as acid stimulation and hydraulic fracturing in February and June of 2008. So it has at least been tried once, and voters are concerned about fracking moving into their backyards and their communities here in Monterey. And they expressly describe that concern in their findings for the measure, in which they said, fracking and acid well stimulation treatments have been used in South Monterey County in the past, and residents must act now to ensure that their use does not expand. That's the finding 3 from Measure Z at page 122 of the administrative record. And as you earlier pointed out, what better time, if there's a concern about the increased use of fracking or the near future use of fracking, to ban it than before it's become widespread and you have issues of potentially takings or vested rights associated with operators conducting fracking. So voters are trying to get out ahead of something that they see as a threat to their communities and to the environment, and that is an indicator of their diligence here, and it's also explains that fracking for Monterey County voters was not simply something that they used to layer on to these other measures, but they're legitimately concerned about it. If we could advance to the next slide, please. So again, the Brosnahan court explicitly said, we reject the contention that the single subject rule requires a showing that each one of the measures' several provisions was capable of gaining voter approval independently of the other provisions. And in fact, there would be almost no way, I think, to make such a showing, and there's no need for petitioners or interveners in the county to do that here. If we could go to slide 2, please. And advance one more. Thank you. So if we look at the actual test, which is whether or not the initiative's provisions are reasonably germane to a common theme, subject, or purpose, we can see that the cases have applied this test post-Jones in the context of environmental and land use measures, consistently define that environmentally protective measures, though they might contain disparate provisions, fall well within the rule. And that was the case in Shea Homes Limited Partnership, a case in which the measure redrew the county's urban growth boundary, altered land use designations, and changed the county's solid waste management and planning practices, but the court found they're all related to a common subject. And the same was true in San Mateo County Coastal Landowners Association and California Gillnetters Association. And all of the ballot materials disclosed to voters each of the 3 provisions contained within Measure Z. Can we advance to the next slide, please? In fact, on the first page, a voter reading Measure Z would realize immediately that the measure contained 3 separate provisions, starting with the very name given to the measure by the initiative proponents. Next slide, please. Which says, protect our water, ban fracking, and limit risky oil operations initiative. It doesn't say stop fracking, period. It says ban fracking and limit risky oil operations initiative. So voters immediately know that multiple operations are at play here. Next slide. I won't run us through the purpose here. Again, opposing counsel has already done that. But we can see here that the statement of purpose includes a description of all 3 of the measure's land use provisions, clearly and fully disclosing them to voters. Next slide. And the effect provision does the same in a little bit more detail, disclosing to voters each of the 3 provisions. So there's no way that a voter reading this effect provision, trying to determine what Measure Z will actually do, what land use policies it contains, that the voter couldn't know, for example, that the initiative prohibits drilling new oil and gas wells in the county's unincorporated area. That's the last sentence of the effect provision. Next slide, please. And again, the voters are presumed to have considered the ballot materials. And although that presumption certainly has to hold true for the question, the ballot question, which voters have to grapple with when they sit down to vote for an initiative, no matter what the initiative is. They need to read this ballot question. And the question here says, shall an initiative amending the Monterey County General Plan, Local Coastal Program, and Fort Ord Master Plan to, 1, prohibit the use of land within the county's unincorporated non-city areas for hydraulic fracturing treatments, acid well stimulation treatments, and other well stimulation treatments. 2, prohibit new and phase out existing land uses that utilize oil and gas wastewater injection and impoundment. And 3, prohibit the drilling of new oil and gas wells in the county's unincorporated areas be adopted. So voters have to know that the measure does all 3 of these things. Next slide, please. Similarly, the county counsel's office prepared a ballot title and summary. You can see the extensive title there that certainly can't fit on a long time. The summary, again, describes and also numbers the 3 land use provisions and what they would do. Next slide. Additionally, this is the county's impartial analysis, which describes individually each of the measure's 3 provisions and effects. Next slide, please. And although the proponent's ballot argument was not required to disclose all 3 of these provisions, it did so, stating that the initiative bans fracking, acidizing, and wastewater injection, and also prohibits new wells. Next slide, please. So, Your Honor, the claim here that the Jones case, which was very quickly followed by the Manduli case, allows for a court to conduct an inquiry into what voters may have or may not have understood about an initiative, just isn't supported by the case law. And we think that the initiative on its face clearly complies with the single subject rule, and that conclusion is only supported by reference to the official ballot materials, which is the proper place for the court to go when considering this question. Thank you.
Thank you, Mr. Broderick. All right, we'll take a mid-morning recess and proceed for 15 minutes.
Remain seated, court is again in session.
Okay, we're back on the record with Mr. Z cases, Mr. Klein.
Matt Klein again, Your Honor, on behalf of CRC. I meant to do this morning, but I went into the argument, and I wanted to thank, on behalf of all of us, the county, the interveners, all of the plaintiffs, first report staff for their excellent treatment of us while we've been here, and secondly, for your real diligent work in this case, being on top of everything. It's greatly appreciated. Not enough. So I think there's a real disconnect here. I heard numerous times from the county and the interveners that we're asking you to apply a different test. We're not. The test is announced in all of these cases. But what Jones holds is that joining together multiple provisions for the improper tactical purposes strikes at the heart of the single subject rule's purpose of minimizing voter confusion and deception. This is applying the same test we asked you to apply, but that's the holding of that case. And I began my presentation yesterday saying there's 2 different strands of cases that deal with these sorts of issues, and we believe we fall in the Jones strand. So I don't think it's fair, Your Honor, for the county to say repeatedly that we're asking you to graft on a new test. We want you to apply the straightforward test there that was announced in Jones and its application, the holding of that case, and we believe that that holding is the one that's appropriate here. The county cited a number of cases, all of which predated Jones in its chart, and none of which grapple with Jones's holding. The case that Manduli, that was cited by interveners and perhaps by the county as well, the issue there was whether voters were adequately informed or not, whether they had been told, hey, we're redoing the 3 strikes law, and what is this whole 3 strikes thing? It wasn't an affirmative misrepresentation case. And in fact, the court went out of its way to distinguish Jones and saying in Jones, what was happening was this fundamental and far-reaching change in the law that was being put in for the act at issue in Jones. And voters were clearly being confused in that case because this fundamental change was being put in the law, and the debate to get them to do that was this false cap on legislators' salary. And here, For the same reasons Mondaly distinguishes Jones, we think Mondaly would distinguish this case because our claim is that there is this far-ranging change that is being sought through Measure Z, which is to basically shut down oil operations over the next couple of years in San Ardo. And that's not what the voters are being told. And the county put up on the elbow its economic impact statement and highlighted it for your honor. But the highlightings are interesting. They didn't highlight, well, a cost cannot be estimated.
That is in connection with
Correct. So, look at the part that's not highlighted. This is the problem, Your Honor. Measure Z's affirmative findings, the affirmative findings that voters got, said nothing, zero, about the effect on the oil and gas industry. And in fact, the proponents got up at meetings and said there'd be no effect on taxes. And their ballot papers said that there would be no lost jobs. The findings in Measure Z is that water pollution could affect the local economy, which is that expanding oil and gas could harm tourism. And Your Honor knows that the center of tourism in Monterey County is Carmel by the Sea, the aquarium. San Ardo is many, many, many miles away. So the notion that these costs were fairly disclosed is just not the case. The second point that was made today was that we should have brought a pre-election challenge. And my client, as you heard yesterday from Professor Thompson, my partner, is that CRC is not up here operating. And what Jones actually counsels and what Justice Kennard criticized the Jones Court for in the dissent was that pre-election challenges are disfavored. And she thought that it was a big mistake for the court to go down that road. And yes, the court in Jones did bend over backwards to kind of deal with this at the pre-election challenge basis. And so there's some statements in there about, hey, we need to deal with this right now. But there's no rule announced in Jones that you could only bring a Jones-type claim before the election. And any suggestion of waiver or the like is just dismisses the mark.
it's not a failure to make a pre-election challenge.
I agree, Your Honor. And
they are disputed.
And I want to be candid, Your Honor. This is a tougher claim for us than the claim Mr. Thompson presented for us yesterday. This is a more difficult claim for us to present because these single subject matter claims, they're not that common. Winkus claims are not that common, but that was just our claims yesterday. I think we showed it as a plain application of that. Here, I do think it's a heavy burden to meet, but I do think we've met it with the evidence and with the common sense test. Now, the county and interveners and all of us agree that you have to look at functional relationship or germaneness. And it's our submission, not that you jettison that test. I refer to that test, I don't know, 20, 30 times during my presentation. And I said the issue with functional germaneness here, reasonable germaneness here, is you're taking a null set. We need to ban fracking urgently. I think the words that the Interveners Council is that we told voters, quote, you must act now. That's what he said a few minutes ago to deal with fracking. But what was the reality? Let's go back to slide 13. Sure, one producer had tried fracking once. And so what happens, Your Honor? And this is just like chemical specialties. They admit, you can look at the legislative history of other acts, other log rolling acts that didn't succeed. What happened? SB4. Groups like the interveners, including the Center for Biological Diversity, they wanted a broad fracking ban in California. SB4 did not give them that broad fracking ban. They came down to Monterey County, and this is all part of the record here, the administrative record. They asked the county, give us a fracking ban. And what did Supervisor Salinas say? He said, I mean, there's no fracking going on here in Monterey County. We monitor that. County staff, fracking is not likely to occur within Monterey County. Supervisor Potter, there's no fracking going on. Supervisor Phillips, the facts are there is no hydraulic fracturing going on anywhere in the county. And yet, intervener just stood up and said, we told voters, you must act now. This is a real threat. It's not. And so let's go back to the original purposes once again, slide 48 of the single subject rule. We saw a lot of ballot initiative materials. This is what the California voters enshrined in the California Constitution, which is a superior law to Measure Z. Yes, Measure Z passed by 16,000 votes on far less voter turnout on that question, and if you look at Measure Y, which is also an issue in Monterey in that election. And the purpose is do not place a proper emphasis on one feature, and the remaining features, which in this case are not understood by anyone. I mean, we've heard multiple different interpretations. I mean, the county and interveners disagree on how to read Measure Z and what its impacts are going to be in its second 2 days. So the one thing we know is common sense governs here, Your Honor. And there's been a lot of discussions about what's the dividing line for evidence. The dividing line for evidence is Your Honor. It's Your Honor's good judgment in applying the rules of evidence in a trial. And yes, you should exclude evidence that is far afield, that is unreliable. Everything we've submitted to you in our presentations here, given the comments that you've made, are very laser focused. They are official campaign advertisements. They are official statements made by the intervening plaintiff in this case. They are official web pages, YouTube channels, Facebook pages from the PMC. These are things that they sat down and deliberated about and put out there. So we're not asking you to kind of go out there. And by the way, this is the first time I've ever had this happen in court where my opponents accused me of making an argument I didn't even make. I didn't ask for discovery. Yes, there was an old slide that we thought about that. I didn't make that argument because I've heard Your Honor loud and clear. So where are we, Your Honor? In the Jones case, they could have come up with all sorts of ballot materials like the ones they created here and listed out all the purposes and made sure that, you know, 1 through 3 was in the official ballot, or 1 through 7, or however many number of points there were going to be. They could have had the proponent statements. They could have had the opponent statements. They could have had the reply statements. And you know what the Jones court said? We don't care. This is misleading. This is ridiculous. We're not going to let this thing go onto the ballot when you're getting people all fired up about this initiative with a lie, which is that you're going to please stop legislatures from paying themselves more money. And here you have the same problem. And again, as Mr. Boutros said at the outset here, we're not here to debate these broader issues about the environmental impact of oil and gas. That's not what we're here to debate. But what we are here to debate is whether the voters were fairly apprised of these issues, whether they were deceived, whether they were manipulated. And again, I'm not asking for a new test to be applied. That's a straw man. What we've said is there's 2 lines of cases applying the same test, and we believe we fall under the Jones test. So with that, I greatly appreciate Your Honor's time and that of your staff, and I apologize for the court reporter because I tend to speak too quickly.
Good morning, Your Honor. Matt Rickersham from Chevron Plans. Presenting a few comments on the due process argument, about 10 to 15 minutes, unless you have any questions. But given that most of these interpretation of issues have already been discussed through in the last 3 days, I feel like we can move through this matter pretty quickly. As made abundantly clear in the briefs and trial proceedings before this court already, there are very vague and conflicting issues regarding the application of Measure Z here. Given the wildly divergent interpretations of Measure Z put before this court, there's simply no way operators and other regulated parties can know, based on the plain language of Measure Z, how it will be applied by the county, or how Monterey County or other strangers to this case could seek to have it enforced by the county. What is clear under Measure Z is that it is an attempt to take away property rights of the oil operators in this county. And despite that intent, we now hear all these other interpretations about every provision of Measure Z. Most of these interpretations, such as reading replacement wells or a exemption for treatment are obviously self-serving attempts to avoid the constitutional takings issues raised before the court. They highlight and exacerbate problems raised by the conflicting language and the alleged purposes of the measure. Given the conflicting language and interpretations by the county and interveners, regulated parties have no idea how Measure Z's prohibitions will be enforced. This creates serious due process problems. This is especially true given the regulatory field of the issue. Oil production operations are extremely complicated, subject to incredibly complex regulations. Terms such as produced water have precise meanings that matter to the regulators, the state regulators, and to the regulated parties. And these terms implicate millions, even billions of dollars in property rights. It is vital that Measure Z provide fair notice how its prohibitions will be enforced. But even more importantly, it has to provide standards to avoid the arbitrary and discriminatory enforcement of this measure by the county. Based on the vague and contradictory provisions and the various interpretations submitted by the county and interveners, Measure Z utterly fails to do so. On the slide, the void for vagueness doctrine has two main components. One of it is a requirement that statute must provide a person of ordinary intelligence fair notice of what is prohibited. But it is a statute or an ordinance is also invalid if it is so scandalous that it authorizes or encourages seriously discriminatory enforcement. And this test applies to speech and non-speech. In the FCC case, it specifically says that even when speech is not an issue, these two provisions are mandatory for ordinances and statutes to avoid due process problems. Each provision of Measure Z here is vague and conflicting and only made worse by the county and the interveners for an attempt to reconcile the language and an attempt to reduce their exposure to takings liability. These issues have been raised and argued previously, so I'm just going to briefly touch upon them here. But these list all the various issues that operators cannot tell what is going to be prohibited under Measure Z if it's actually going to be enforced by the county. Under the Measure Z's well stimulation prohibition, it's unclear what facts must be proved.
Can you slow down?
Oh, sorry.
We're both struggling to keep that court reporter in. Thank you.
Apologize, Your Honor. Under the well stimulation prohibition for Measure Z, it is unclear what facts must be proved for the use of acids for maintenance. We showed you previously the testimony from the Tubbs Declaration showing, at least for Chevron, that acid is needed to do maintenance and do cleanouts in the operation in San Ardo. Unlike DOGGR, there's no test incorporated in Measure Z to provide a way to distinguish between allowable acid maintenance and prohibited acid stimulation. And in fact, in the additional documents that we submitted to Your Honor yesterday on the supplemental standing brief, we attached documents from DOGGR's notice to operators showing that DOGGR controls how this test is applied. It wants to be involved, and it is not a specific or clear set of standards like in the Associated Home Builders case that the county can just adopt here verbatim and enforce on its own. It's a test, it's a complicated test, and it has to be applied by DOGGR and with the expertise that they have. The prohibition in Measure Z permits steam injection to continue for under the well stimulation section. The next section, prohibiting injection, prohibits the injection of produced water for storage. The county ignores this second prohibition and argues that steam injection and injection for steam flooding is allowed because it is exempted under well stimulation section. That's not a reasonable reading of the statute, but all steam injected at San Ardo is produced water. And that produced water is injected as steam in order to be stored in a steam chest. Clearly, the injection for storage and appears to be prohibited as a matter of Measure Z. And although the county and the interveners do backflips to try to reconcile these provisions, they only exacerbate the vagueness issue by claiming that the steam chest is not storage of produced water. On the third point, the reverse osmosis plant
must impound produced water in depressions in the ground, which is expressly prohibited by Measure Z. The findings of Measure Z suggest that the operation of the reverse osmosis facility can continue despite these prohibitions. This vagueness issue is only made worse by the county intervening, or the county now trying to inject an exemption for treatment, which is also apparently joined by the interveners to some extent. Neither of them provide any type of standard for what level of treatment is needed to avoid application of Measure Z. In any event, any determination here is exclusive within the jurisdiction of DOGGR and the Regional Water Board and the US EPA. And as shown by the documents that have been produced by these agencies, regulators and operators have always understood produced water to mean produced water, even after it goes through the reverse osmosis facility. And we provided before the staff report on that reverse osmosis showing that even after it's being discharged, it's still defined as highly treated produced water. Finally, the no new well ban conflicts with Measure Z's purported allowance of steam flooding operations. And the county interveners have created even further vagueness problems. The county reads in a replacement wells exception into the measure, and the interveners do not even agree with this, but both county and interveners argue that sidetracking wells are permitted, even though sidetracking requires a new well bore, new casing, and a new drilling rig, just like you would need for drilling a new well. Measure Z violates due process by forcing persons of ordinary intelligence to guess at what the initiative requires. More importantly, what enforcement might follow if operators fail to abide by these vague regulations. Measure Z intrudes upon areas of complicated technical regulations. And oil and gas operators in this field need to know certainty and notice long in advance what the scope of the regulation is and what conduct is prohibited and allowed so they're able to structure their business plans to meet those requirements. As we discussed earlier this week, DOGGR is an agency staffed with technical experts to prepare detailed regulatory guidance on the application of these rules to the oil operations. And Measure Z intrudes upon this area and will cause significant uncertainty, potentially vast expense to operators. And on top of that, the county and interveners now add conflicting interpretations, apparently untethered from any factual support in the text of the measure. These conflicting interpretations only exacerbate the constitutional problems inherent in the measure and cause operators to lack any notice as to how this measure will be applied. This is very similar to the Schweitzer v. Westminster investments case, where the court was considering a statute requiring bonds for the sale of property. And it held that even though the agency tried to impose a requirement or interpretation that was based on what the court called sound economic considerations, that interpretation was untethered to any statutory language and therefore was not sufficient to save the measure. It says whatever merit this argument has, and this is on page 1208 of the Schweitzer case, whatever merit this argument may have, it introduces or perhaps merely reveals yet another ambiguity in the statute at which persons of common intelligence must necessarily guess. And as a result of that, the court held, based on all these various components of the statute that were vague, amorphous, and could not be enforced, it held that the measure was barred under due process. Just like here, based on how the county and interveners are asking this court to interpret Measure Z, it provides no guidance as to asset maintenance, produced water storage, produced water treatment, replacement wells, sidetrack wells, or the enforcement mechanism for how Measure Z will be applied. Measure Z intrudes upon an extraordinary complex regulatory field with its own language and terms, and in particular, as in the Hunt versus City of Los Angeles case, the court held that where a broad definition of statute is so murky that enforcement of the ordinance poses a danger of arbitrary and discriminatory application. And in that case, is where a police officer was provided basically no guidance as to what type of stalls could be set up on the Venice Beach Boardwalk. And we held that there was no delegated to the county highly factual specific analysis that created the risk of arbitrary and discriminatory application in the enforcement of this measure that is a violation of due process. And unless you have any questions.
Are you going to be addressing section 6C at all as part of your due process?
No, Ms. Wells will be addressing that after we hear from the county interveners as to their arguments.
Okay. Thank you.
Good morning, Your Honor. David Ball for the trio of plaintiffs, and I'll be brief on due process. I just want to piggyback on a couple of things that counsel noted. First, in framing the due process argument, I think it's important to look at the purpose of Measure Z. Interveners, perhaps shockingly, were a bit candid in their brief, and they said Measure Z was implemented because DOGGR failed to carry out its statutory obligations, and so concerned citizens took the matters into their own hands. And that's on pages 2 and 3 of their opposition brief. And I think that really does frame what's going on here, Your Honor. In terms of due process, as counsel noted, there are two issues. One is a reasonable person has to understand what they can do, and the second one is a reasonable person enforcing it has to understand how to enforce. And I think the colorful language that gets used in these cases, arbitrary, indiscriminate enforcement, if it is to be prevented, laws must provide explicit standards for those who apply them. A vague law impermissibly delegates basic policy matters to policemen, judges, and juries for resolution on an ad hoc and subjective basis with the attendant dangers of arbitrary and discriminatory application. And that's the frequent recitation. The one site I'll give you is People v. Superior Court, which is 46 Cal 3rd 381. And it says that case also says, where the legislature fails to provide minimal guidelines, the statute may permit, quote, a standardless sweep that allows policemen, prosecutors, and juries to pursue their personal predilections. Now, why do I raise that in this context, Your Honor? Well, Your Honor has already noted the elephant in the room. When the county has to interpret Measure Z when there's an application in front of it, it has a tremendous incentive to be creative in its interpretations to minimize downside risks. We saw that with the interpretation of the no new wells provision, where they injected an interpretation that meant no new net wells. And I think Your Honor saw through that. Interveners don't even agree with that. Of course, it's not in the text. But here's the insidious nature of that, Your Honor. The distinction they draw is driving a wedge between producers. It's driving a wedge between Chevron and Aera on the one side, who, if the county's interpretation was correct, would have wells they could take out of production to put a new well in. And the more minor producers on the other side, the exploratory producers on the other side, who would not have a well to take out of production to put a new one in. So they are creating an interpretation that A, is wrong, but B, begins to discriminate against classes of producers. And the concern that we would have, Your Honor, is if this type of issue came up again, and the county were to say, how do we minimize the impact? They're going to look at minimizing impact from a financial perspective. They've already admitted that they could face bankruptcy with losses. It's in the assessor's audit, Your Honor. And so the problem becomes we have given over to the county a regime whereby they can arbitrarily interpret these very vague provisions that council put up there in a way that would minimize liability, but in so doing could start drawing classifications between larger and smaller producers, non-producers, exploratory producers, based on who they thought might have a larger claim. And for that reason alone, Your Honor, the Measure Z is just insidious. And with that, I'll rest, Your Honor.
Thank you.
Thank you very much.
Mr. Render?
Yes, Your Honor. I still have a difficult voice, but I'll try and make myself very. I'm just going to be very, very brief. The other day, I handed the clerk to hand to you a map, and you may have it up there. And I'd just like to, oh, here it comes. And this is just a start one. But what this is a map that was prepared by my expert, Wayman Gore. It comes from his declaration, which was appended to my opening brief. And what he did was he started with the map that the county had developed in the EIR for its general plan, and which has on it, you'll notice the green, the two shades of green and the yellow. What those are the areas of scenic concern, yellow being vital and so on. So the point I wanted to make here has to do with blowing down any idea that we're talking about proper zoning here when we're talking about Measure Z. The big oil production in this county is down in South County. Oh, but I forgot to tell you that what Mr. Gore did was then superimpose on that map all the wells for which permits, even just core holes, for which it had been obtained since I think the year 2000. So when you get down in the south to, if this were blowing up big, you'd be able to see it. But when you get down to the south, all the drilling activity has been around the San Ardo area. I mean, to see that is a continuous black blob made up of a lot of individual dots showing if nothing else, it shows the geological and engineering need to drill a number of wells in order to produce heavy oil fields. And of course, my clients are South County people. And when I look at zoning, I say, wait a minute, what is there? Why do we need, I mean, I can understand that there are places where you don't want oil wells in this county. No one is talking about putting oil wells on Pebble Beach, Your Honor. Absolutely not that's not what this is all about. But why in the world are we taking aim at the South County where oil is concentrated, where it is important to the lifeblood of the people down there, and is far removed from the touristy areas of the county. And as we can see on the map, there's nothing that the San Ardo area is doing that's going to have any impact whatsoever on the visually sensitive areas in this county. That's a general observation about zoning, which, as all of the cases have said, and we've heard a lot about all the zoning cases that have restricted oil. Every one of those cases say that your zoning can't be arbitrary. And I'm saying that when you zone oil, try to zone oil, and I don't accept, and I'll get to this in a minute, that what they're really trying to do is zone oil out in South County. They're trying to do something else, and we'll get to that. But you can't justify what they're trying to do in South County as legitimate zoning. It just doesn't fit the bill. Now, let me turn to one, I'm going to talk about a case, and I can get through this very quickly. I want to tell a little story. On July 3rd, 1919, the the city of East San Diego enacted a municipal code section declaring that any hospital for the treatment of patients with contagious or infectious diseases was a nuisance. In short, the ordinance was saying that you can treat people with broken legs, but don't treat people with infectious diseases. Any hospital that did so was declared to be a public nuisance, and by the way, they started enforcing that law with criminal sanctions. In the case of San Diego Tuberculosis Association v. East San Diego, it's a 1921 case, 186 Cal 252. The California Supreme Court had no difficulty whatever holding that this was arbitrary and unreasonable, and therefore unconstitutional. So now, in 2016, along comes Measure Z, which enacted new general plan policies that had the effect of doing three things: preventing oil and gas operators from using any well stimulation treatment that increases the permeability of oil and gas-bearing formations. That's LU 1-21. Two, using any well to inject wastewater into the ground for the purpose of disposal or storage. That's LU 1.22. And three, drilling any new well for the purpose of exploring for or aiding in the recovery of oil and gas. That, by the way, Your Honor, is broad enough to cover, if we are, but it's broad enough to cover, I suppose, even drilling a drinking water well to provide potable water for the oil and gas, for the employees working in the San Ardo field. That's a pretty broad statement. Now, this is so, even though it obviously, we know that this permits water flooding, steam flooding, and cyclic steaming. That's in the law, in Measure Z. And the fact of the matter is,
we don't know that it permits, it excludes those processes from the definition of well stimulation.
well,
But not saying that it actually permits them to take place.
well, Your Honor, they sold it to the public on that theory. They told the public that, and I can show you statements that as a logical matter, you're absolutely right. And the county has tried to make that distinction, or maybe the interveners make that distinction. I say that is a bogus distinction because as a practical matter, they went to great lengths, and in this trial have gone to great lengths to say that, look, we didn't require, we're not shutting you down. We're not shutting down the oil business because you can still you can still do water flooding, you can still do steam flooding, and you can still do cyclic steaming. So therefore, you haven't been harmed. What are you worried about? This is just another regulation. And what I say is that yes, it is. In effect, the only logical conclusion you can draw from looking at the language is they are going to let you water flood, and they are going to let you steam flood, and they are going to let you engage in cyclic steaming. But you put your finger on a key point, because there is essentially no difference as far as surface land uses go from injecting water into the ground for steam flood or injecting water into the ground for disposal or storage. It's the same equipment. You have a pump and you pump it down into the ground. and you're pumping it down into either oil fields currently producing oil zones or oil zones that previously produced. You're pumping it into presently producing zones. If you're using it as a well stimulation technique, you are putting it probably into previously producing zones if you're using it to dispose of. So, once again, I ask you, what in the world is the logic of that? And if you look back at the map and you see that we're talking about oil fields that are way south in the county, what is the logic that makes sense out of that kind of a requirement? Why are we so concerned? Why are the proponents of Measure Z so concerned about trying to attack what's going on in presently existing oil fields that have been around 60 or 70 years? Well, the answer is they're trying to shut them down. We can't have evidence of that. That's what's going on here. I don't, let's not kid ourselves. Now, so what I'm saying is that we have these two fact patterns that are in some respects very, very similar. And I say neither of them, we're talking about the hospital on one hand and take, say, the San Ardo oil field on the other. Neither of these, none of the Measure Z regulations can be justified, and none of the hospital regulations that were imposed on East San Diego can be justified under the police power to zone. Because zoning is about limiting land use within a neighborhood to compatible uses. And I guarantee you that injecting wastewater for, say, a water flood or a steam flood, and injecting wastewater to dispose of it, one, the proponents would say is prohibited, and the others, the proponents would say you can do, are alike as peas in a pod. There isn't any distinction that you can see between those two activities. So, now what am I getting to? Well, I'm getting to this. The court in San Diego Tuberculosis Association, the East San Diego, dealt with this for what it was, a nuisance case. They were the city fathers of the city of East San Diego were trying to turn hospitals that took care of contagious or infectious diseases into nuisances. They're public nuisance, so we're going to ban them. And the court said, well, you can't do that. You can't do that without a showing that no matter how well that activity is conducted at the hospital, it is nevertheless a menace to public peace, morals, health, or comfort. And as I say, the Supreme Court had no trouble tossing out that regulation. And I say the same thing here. There has been no showing, and can be no showing, that the oil business, which is a legitimate, important business in the United States, without which, you couldn't go to the grocery store and buy some English muffins tomorrow morning if you didn't have gasoline, or if you didn't have electricity to run your electric car. I guess you could ride your bicycle there, but the English muffins wouldn't have gotten there because they came in last night by truck. So they cannot show that the oil business in San Ardo, I'm not talking about putting an oil business on Pebble Beach. I'm saying the oil business in San Ardo and Lynch Canyon and the the other area, the other fields in those areas, have not been shown to be any kind of a menace to public peace, morals, health, and comfort. And on the subject of relevancy, Your Honor, we produced an exhibit which is also attached to our opening brief. That is the opening brief of Aera and the 80-plus individual clients we represent in South County, which is a declaration prepared by Mr. Stephen Boyum, who's a scientist with the he's a scientist who was for a period of time called in by Jerry Brown to cure some problems at the state, the Division of Oil and Gas and Geothermal Resources. And what he does is he, to my way of thinking, does a very adequate job, very good job of dismantling the 15, quote, findings of fact, close quotes, that are contained in Measure Z. What we then have, I think, is very clearly those findings do not cannot show, particularly when one stacks them up against the declaration that I just mentioned. They cannot show that the oil industry in the South County is a menace to public peace, morals, health, and comfort. Simple as that. They can't shut us down. And unless you have some questions, I will now subside and not inflict my voice on you any longer.
Thank you, Mr. Moon.
Good morning again, Your Honor. Sean Haggerty on behalf of the County of Monterey in all cases.
Good morning.
I'd like to start our discussion with just a reminder of what type of a legislative action we're dealing with. This is a general plan amendment. The general plan provisions sit at the very top of the entire land use structure. They set out sometimes prohibitions like we have here, sometimes policies. They are typically fairly broad in nature, and then they're implemented through things like specific plans or zoning ordinances or regulatory requirements that move down the chain. And typically when that occurs, there's a movement from, back to the original. There's a process where things get more detailed as you go down the chain. And so for due process purposes, we need to remind ourselves that that's the type of document that we're dealing with here. It's not something that is intended to or could answer every question. It, in and of itself, will lead to further implementation, testing by this court, potentially future courts, the county. It's important to just remind ourselves that that's what we're dealing with, and this is not something that can emerge fully complete and answer every question. And I think it's inconsistent with general plan standards and due process requirements to criticize it for not answering every question. Obviously, it needs to be assessed for what it says, there is room and future processes that can occur to provide more detail. The second reminder is that we are also dealing with an initiative, and we fully briefed this issue. Mr. Tanaka started with this point in his very first comment. But initiative is a precious right, and it's the court's duty to, when it can, uphold that right. Now, obviously, that doesn't mean that there aren't decisions, there couldn't be decisions where initiatives have problems, and sometimes they do. But the framework that we need to approach this segment of the discussion, the lens we need to look at it through, has to take into account the nature of the document and the fact that it's an initiative. So if we go to the next slide. So plaintiffs have, in their briefs and here today, raised three types of due process related arguments. The substantive due process argument that you just heard at the end, the whole concept of void for vagueness, and then I think trio today and a lot of discussion yesterday about the challenges to the exemption process. So my original plan in thinking about how I would present this would have gone in that order, but given the court's discussion yesterday, I think it's appropriate to readjust that plan and to really dive right into the exemption process and deal with the three key points that I think were discussed and the court had questions on, dealing with Birkenfeld, the line of cases in Hensler and Healing and Action Department, and then this question about the standards and how significant or how detailed the standards need to be at this stage for it to pass muster under the due process requirements related to void for vagueness. I will then come back to the other issues as I had originally planned to do. So partly I'm just saying that because you're going to see me shuffle papers around and
That's fine.
yeah. So let's start with the key point, and if we could go to slide 9. So, Your Honor, I'm going to leave this up here. It's not going to tell us very much because I'm just going to walk through these cases, so we shouldn't be distracted by that. But these are the cases that I'm going to try to deal with and explain how, based upon these cases, the exemption provisions in Measure Z should pass due process analysis. The court asked a number of times yesterday about other examples of a process like this, the exemption process. And it was argued by the county, by Mr. Tanaka, and by the interveners that there are several cases and examples of this, and it was argued that this is a common land use process. And we believe that that's absolutely true. And the cases we pointed to were San Mateo, where there's a specific process articulated in the case that's the same as 6B of the measure. The Williamson case, which deals with variances, which are by definition designed to provide a constitutional safeguard for the application of land use decisions to individual properties. We also pointed to the Livingston rock and gravel case, where there was a process that allowed the zoning entity, the land use decision maker in that case, to assess whether something might impair property rights. And then we didn't go into a great deal of detail on it, but we did talk about the fact that the county has its own, currently, and has used previously, the vested rights process. Now, we haven't put into evidence the examples of those previous decisions, but if there is a process that the county has already related to vested rights. So,
Isn't there a difference between
No, and I don't think that's what Measure Z says, Your Honor, and I'll try to explain that because I don't think Measure Z, and I'll try to convince you of this fact, requires the Board of Supervisors to make a judicial determination in the way it's been characterized. What I think it does, and I think it's expressed in the requirements, is require the Board of Supervisors to look at these 3 general plan provisions and to assess, using its normal land use power and processes, to say how would this, those application of those provisions apply and impact either vested rights or, even if not vested, property rights that may cross a constitutional threshold. So there clearly is a requirement for the board to think about constitutional principles, and I'll try to persuade you that that happens all the time. But this is not a situation where the board is usurping the power of the court. All it is a situation which I think the 4 examples I gave you, and then some of the additional examples I'll try to give you, the land use decision makers do this all the time. This may be a more detailed, well, no, I wouldn't say detailed, more robust example of it with, a fairly, based upon the oil industry's position, obviously very important issues. But the board deals with important issues all the time and should be given the opportunity to do that here. So if it's okay with the court, I'd like to try to get to those questions by looking at the Birkenfeld case, the Healing, Hensler, and Action cases, and then the Braden and Hunt cases. And in the process, I'm going to try to give you 2 other examples that are embedded in those cases where this type of approach is used by either elected body or an administrative body, and where their job is to apply certain rules consistent with constitutional requirements, and that's not a problem. In fact, that's inherent in the system that we have for land use. So that's what I'm going to try to do. So if it's okay with the court, I'd like to start with Birkenfeld. So Birkenfeld is being used to say that there's somehow just a complete inability of entities such as the board to provide a timely process to assess key issues through an administrative process. What Birkenfeld involves is a very specific charter amendment that established a rent control board that was empowered to establish rents because of a concern that there was a shortage of apartments and other units within the city of Berkeley, and that created a situation where property owners could significantly increase rents in a way that would have a negative impact on the city. And so this measure was passed. The court said there's a valid public purpose with this measure, and in fact looked at the general purpose, and from that came up with an implied standard related to that purpose that has become the hallmark of rent control cases, and that's the just and reasonable rent standard. In the case itself, it uses the term just and reasonable rent and no more, consistent with the provisions of Section 6 of Measure Z in terms of where you draw that line. But what the discussion yesterday and has been, and the court's question later on, is the process itself. And what was wrong with Birkenfeld was actually how detailed the charter amendment itself was. Because what happened in that case is that the court found on its face, it was a facial challenge like what we had here, the court found on its face that because of that detailed procedural requirements, the measure put the board in a procedural straitjacket. So specifically, they I think as counsel for intervener explained yesterday, that required individual applicants, individual applications for each unit, and there were somewhere between 16,000 units to 17,000 units. There was no ability within the measure, so the board was prohibited from delegating to staff or to a hearing officer part of this function. There had to be individual hearings, and the board members were not paid, and so they were having to hear 16,000, 17,000 hearings without being compensated at all to do that. And they were denied the ability, the means to develop for themselves a more manageable process. So those were the constitutional concerns that the court really focused on, because the board, because of this procedural straitjacket they were in, the court said there can't be a meaningful process here because the hallmarks of a meaningful process you're prohibited from engaging in. Measure Z doesn't suffer from those constraints. In fact, it's been criticized as being not having enough procedural specificity. But I think that's, given what Birkenfeld found, that's a virtue. That's a good thing because the measure allows the board to develop, unlike Birkenfeld, a manageable process. And we've submitted evidence that the board is engaged in that process, getting public input on that process, allowing everyone to comment on how to make this a meaningful and manageable process. Part of that process, at least in the draft form, anticipates addressing the Birkenfeld concerns by allowing, for example, consolidation of applications, individual hearing officers to expedite the process, and other means to move the process forward in an orderly fashion. And unlike Birkenfeld, where there were these specific procedural straitjacket constraints, because Measure Z doesn't contain those requirements, on its face the court is unable to say it's going to suffer from the same defects that Birkenfeld had. So it's the county's position that the county should be allowed to move forward with this process, to develop a meaningful process. We think that it should be presumed that the county will do its job consistent with requirements and do it in a way that's consistent with law and in a timely fashion. And so rather than being a concern, it seems that Birkenfeld is actually an illustration of why this measure is, unlike Birkenfeld, an appropriate process. So I want to just take a second to say that Your Honor had asked for additional examples, and while maybe not the perfect example, Birkenfeld and the line of cases that follow from that, and I'm not introducing anything new here, it's reflected in Action Department. We've cited the Kavanaugh case, which is a rent control case. There's been discussion of the MHC case, which is a rent control case as well. But I would submit to the court that the rent control is another example where an administrative body is guided by constitutional requirements. In this case, as Birkenfeld articulated, the just and reasonable return, or it's often referred to as a fair return. And there's an analysis that those boards have to go through to allow rents to be adjusted to be consistent with those requirements. And if they're not, then people can challenge that decision, and it's reviewable in court, and also subject to separate judicial review through an inverse condemnation action. So again, while not the perfect example because it's not a specific land use example, it is another example where administrative bodies, including often city councils or boards, who face some of the pressures that have been talked about, but do the job and do it consistent with their legal obligations. And it should be presumed that that's what would occur in this case. So let me talk next about the line of cases involving Healing and Hensler and Action Apartment.
Mr. Haggerty, I let him know I'd be saying this. I'd like to note a brief objection to the record. We spent hours yesterday talking about 6C and these due process challenges. Mr. DOGGR was able to present extensive arguments on that. The
I was
internet
asking an invite for the comment because I have real questions about
and I understand that. Unfortunately, Mr. Thompson's not here today. Ms. Wells will do an able job, but I'm a little bit concerned that they're getting a kind of second bite at the apple. But if it's at your honor's inquiry, we have no objection to going further.
Thank you.
The court asked yesterday, specifically to the question that the court raised when I commenced, about this concern that's been raised about whether Measure Z inappropriately allows the board to usurp the judicial function. And the line of cases, it starts with the Healing case and then goes to Hensler and then goes to Action Apartment, have in them a brief reference to that there being a distinction and that administrative bodies shouldn't have the ability to adjudicate whether their own actions are violate the Constitution. So I'd like to focus on that line of cases. Let's start with Healing. This is a denial of a coastal development permit. Really, what the case actually involves is a question of whether inverse condemnation, whether a claim for inverse condemnation is separate from a writ challenge. And basically, the question, argument was, if I have to challenge this only by writ, then that raises the concern that the administrative body can build a certain record, and then I'd be limited to that record, and it would be prejudicial. And that's, in that context, that's where this comment about can't be both the decider and the reviewer of that decision. So it's really a procedural case, and the commission in that case did contend that a taking should be decided by writ based upon the administrative record and subject only to the 1094.5 evidence limit. But the court said that's not appropriate. You should be allowed to separately bring and not be limited to the evidence that the administrative body heard. But you can separately bring an action for inverse condemnation, and that the writ itself is not an adequate substitute for a trial by the court. And if there's a liability found, then an assessment by a jury is what the just compensation is. So we don't disagree with that. We don't think that that has any impact on Measure Z because Measure Z doesn't provide otherwise. The board under Section 6 has an important land use role to play in deciding how to apply the measure's provisions. It's not intended to be a substitute for judicial review. In fact, they work in tandem. And there's a value there because it may be, as was pointed out, and there were some nice slides from the presentations yesterday with decision trees and what results may follow from more decisions. But there are situations where the board might exercise its land use authority under Measure Z in a way that would negate certain claims, and that would be efficient in terms of the process. And we think that healing, again, rather than being a problem for Measure Z, actually demonstrates and recognizes that there is a dual role, and as long as there isn't, as long as there's a chance to review your inverse condemnation by a court and potentially jury the decision, the land use decision that's made, that's not a problem. So we don't, the reference at the end to the limitations on the commission and it not being authorized to decide issues of constitutional magnitude, I don't think that's really in the context of this procedural question.
There's a policy behind it, it's the thinking behind it. And wouldn't you agree that the possibility of a biased decision as to whether or not there is a taking is much greater when the agency that's going to have to pay for it is the one making the decision?
Your Honor, that is the situation that every agency is always in. As a land use decision maker, you're always subject to these constitutional requirements.
That a court might determine.
Absolutely. Absolutely. And, sorry.
But in this case, you are entrusting that body with making a decision at two separate stages of the proceedings. First, whether there is a taking. And secondly, if there is, and they decide to grant an exemption, how far can they go? What's the minimum amount that they can get away with so that it's not a taking?
I don't think Measure Z requires the board to make a determination regarding takings in the way that a court would make a determination regarding takings. It's really, you need to focus, I would suggest you need to focus on where the where the board would be coming from. The board would be making a land use decision to assess whether the specific three requirements or prohibitions in Measure Z, whether those, if applied without alteration, would impair property rights or vested rights. So,
would constitute a taking under the United States or California constitutions.
yes,
That's the standard.
but that's the standard. I mean, that's what the Constitution requires, that land use bodies abide by those requirements all the time. And land use decision makers are required to do that, and in their decision-making process have to think about that all the time. Now, I think the key point is, if there were no right of review, and if it really said that somehow you couldn't independently review a board's assessment of how these provisions as applied to individual properties may implicate constitutional provisions, then I think that there would be more of an issue. But that's not what the law says, because cases like Heelan and Hensler made clear that that's not the case. And it's not the county's position, and I don't think Measure Z on its face suggests that there is some kind of finality to the board's independent assessment of constitutional requirements as it relates to their land use decision-making process. That's subject to review.
Is there any case reported that involved an ordinance that purported to delegate the authority to an administrative agency to determine whether or not its actions were a constitutional, a taking under the Constitution?
Okay, so let me give you, I'll go back to the examples we've already provided you, because we think that has that similar line. But let me give you another one.
Just simple references to things that say that you shall act in accordance with all laws or in accordance with the Constitution and the laws of the state of California are not sufficient. This goes further. This ordinance goes much further than that. And is there any case that involved the same language that this ordinance has?
Well, I don't want to retread ground, but San Mateo involves the same language as 6B.
It said that they are to determine
No,
whether or not there's a taking under the United States Constitution.
It involves the same language as 6B, which has a different version that works in concert with 6C. Let me see if I can shuffle my papers to find it. And I think interveners had a nice slide comparing the San Mateo with the languages of 6B. So 6B says the provisions of this initiative shall not apply to the extent, but only to the extent, that they would violate the Constitution or laws of the United States or the state of California.
And that just tells them you've got to abide by the law. It doesn't say you get to decide what it is.
Well, we're not, I think we need to drill down into that, because that's the distinction that the county doesn't see that distinction. We're not deciding what the law is. We're applying Measure Z. We'll have to apply it. We're not doing it now. We're in the process. We'd have to assess how these prohibitions in Measure Z would affect property or vested rights, and then make a decision about whether the board needs to scale back the provisions to be consistent with the board's view of where that line is. And that's not a conclusion of law, because only a court can make that conclusion. But it is an assessment of where the board thinks that line is, subject to judicial review, and that's what we do all the time.
Isn't whether or not there's a taking a question of law?
Ultimately, the final determination of the taking is for the court and for a jury.
And the jury doesn't decide whether there's a taking.
Correct.
The jury
Just
decides
compensation.
what just compensation is, which is another point that we'll get to.
Right.
It's inevitably, these disputes are going to end up here, not finalized before the board of supervisors.
Yes, I mean, maybe, we can't presume that, but I suspect that there will be, like there is with the Coastal Commission, like there is in the rent control cases, there will be lots of litigation related to this. But that's the process that the voters decided that they wanted to have, and it's consistent with legal requirement. And Healing and Hensler and Action Program don't say otherwise. They do not say that this type of a process is unconstitutional or improper. I grant you that they use the phrases that plaintiffs have quoted. And again, if there were some provision in Measure Z that said this is not a reviewable decision by the board, or somehow empowered and prohibited people from challenging how the board applies it consistent with these constitutional requirements, then we would have a problem. But that's not in Measure Z. And you can't tell from the face whether that will be a problem.
Under the Penn Central test to determine whether or not it's a taking, there are many factors that have to be weighed in making an adjudication as to whether or not that's a taking, correct?
Yes. No,
Professor Thompson indicated yesterday.
yes, there's many factors.
That's a question of law.
Ultimately, that's a question of law for the court.
And this ordinance purports to give that authority to the board of supervisors.
That's where I don't think the language can be read to empower ultimately without sense that this is subject to judicial review, because let's look at C. One, inconsistent with these Healing, Hensler, and Action Department cases, I think there's been a critique or criticism of C because it uses the substantial evidence requirement.
It's another area we need to
Well,
talk about.
that's land use basic requirement. That actually shows that the concern that the court has, which I understand, and the arguments that plaintiffs are making, that's not the intent of this provision.
What is the purpose of that provision?
It's to allow the Board of Supervisors to use its land use decision-making process in a way that would implement as much as possible the goals of Measure Z, but in the board's view, be consistent with constitutional requirements, subject to judicial review. That's what this process is about. And if I can make one point, and I think it will help. I was going to work through Hensler in action, but I think we need to jump right to it. But
I'm not going to cut your argument short.
I want to make sure I'm covering the court's points, but there is, in Healing, there's a reference to the Coastal Act provision 30010. And that provision basically says that the Coastal Commission or local agencies that are acting under the Coastal Act, so if the county were to be acting under its local coastal program, that they cannot grant or deny a permit in a manner that will result in a taking. I'm paraphrasing a bit, but that's what it says. And there's a case that I provided notice to plaintiff's counsel because it hasn't been briefed, but it's a case that the court should look at, and that's the McAllister v. California Coastal Commission case. It's 169 Cal App 4th 912. And what that case says is that the Coastal Act provision that I just cited allows the Coastal Commission or the implementing agency to deviate from Coastal Act or local coastal program requirements if the application of those requirements to grant or deny a permit would result in a taking. And so it's a similar safety valve as the one contained in Section 6. It's not, the language isn't exactly the same, but I would submit that the application is very similar. And what McAllister actually talked about is, in that situation, I believe it was the Coastal Commission did in fact ultimately deviate from a requirement, and then that was subject to review, and basically the court said, you Coastal Commission, you didn't make the right findings about whether there was in fact a taking and whether the deviation that you allowed was appropriate to prevent that taking from occurring. And so it sent it back down. And that, again, is the type of thing that would occur under Section 6. So the board would make a decision. It would base that decision on substantial evidence. It would make findings. And yes, those findings would be based upon legal principles related to the Constitution, Penn Central, if that were applicable, or some of the other cases we have talked about in the takings discussion. That would be subject to review, and also there would be a separate ability under Healing and Hensler, to bring an inverse action. So I understand that the court is concerned about this process, but these cases demonstrate that this is a common exercise that boards go through, and it is not a usurping of the court's authority. In fact, it's an appropriate balance between the land use decision-making function, requirement of findings, and judicial oversight, both with regard to those findings and with regard to ultimate questions of liability for inverse condemnation. And Measure G doesn't say otherwise in our interpretation of it, Your Honor. I think with that, I'm happy to talk about Hensler in more detail in Action Department. I don't think it's likely worth the time because I think we've made the point we want to make, but Hensler was ultimately really a statute of limitation question. But it did involve the same question about writ review versus inverse and how you look at some of these questions. And if anything, Hensler backs off a little bit from some of the provisions in healing, but we think that actually Hensler supports the holding of the measures in these provisions. And action department, while it quotes the language from that line of cases, it really is the holding, at least as we see it, is security deposits weren't within the purview of the rent board at all. So there was no remedy that they could do. So the idea that you had to go to the rent board to get something that board had no legal authority to address at all. So it'd be as if Measure Z said you got to go to the board, but the board couldn't apply Measure Z's three principles to it. That's what we think that case stands for.
I do have a question.
Yes.
Yesterday, we heard from Mr. Kreisman, and I think it was his decision tree he had on the board there, talking about the ability of the board of supervisors to determine if there was a taking to award damages, and that there would be a taking to award damages. Is that the county's position?
I understand what Intervenors Council was saying in the sense of the decision tree. Certainly not something that, at least in our procedures that are being developed, that is something that is under consideration. Really, the procedure is going to be about does the application protect a vested right or cross the taking threshold in the board's opinion, and such that it would allow relaxation. So I don't think there's a contemplation that there'd be a decision to apply it and pay money for it. And even I do agree with his comment that even if that happened, that would independently be subject to review. Maybe I think I could get through one other section and then. So the last concept that was discussed really focuses on these the Hunt and the Graydon case. And the question really is here about the sufficiency of the guidance in Measure Z for the board to perform its land use functions, to apply Measure Z in a way that doesn't result in the taking or impair of vested rights. I agree with the county agrees with the intervener's comment about these cases just in general. These are, of course, amendment cases. They involve arrests and convictions. They're very different than what we're looking at here. So engaging, it was actually a person was convicted for engaging in a demonstration. There was an anti-noise ordinance. The case actually upheld the anti-noise ordinance in the application to this situation on due process grounds, saying that while there was some potential vagueness as applied here, it wasn't permissibly vague. And so this case doesn't help, I don't think, in our view, get to the concern that the court has expressed about the standards. And again, particularly when you're looking at a general plan level initiative. Hunt, that is being cited for this idea that you can't take a case or a legal concept and sort of make that the standard. But again, that case is very different. It's a vending ban involving the First Amendment. There was an arrest based upon the ban. And there was this reference, and they did, this LA tried to have a safety valve referring to a previous case, but I think as counsel for Chevron mentioned, that case dealt with how a police in the moment, in an instant, has to make a decision about whether this ban applies or not, walking down the street and trying to determine whether something is inappropriate vending versus appropriate vending. And clearly, that's not a situation where a police officer is going to be able to refer to a separate case and understand the meaning of that case and apply it in that instance. There's nothing inherently wrong with referring to constitutional standards in an ordinance and saying that when you exercise your land use authority based on substantial evidence, you shouldn't impair property rights in a way that violates those provisions. So I don't think Hunt gets to the point where plaintiffs wanted to go with, which is that somehow there's something wrong with 6B or C's reference to constitutional takings or to the Constitution. And again, these other cases, the Postal Act provision, McAllister, the rent control cases, that process is engaged in all the time, and there's nothing inherently wrong with it. And certainly, the provisions of Measure Z, well, subject to scrutiny, aren't so vague that the board can't implement it. And in fact, it's doing that, and I think the board should be allowed to do that and implement the measure and move forward. I think that would be a good place to stop.
Okay.
I have more for the afternoon, but hopefully you'll have
Yeah, let's take a break here. We'll do the recess at this time. We'll resume at 1:30.
Thank you.